We're shuffling the schedule around a little bit. We're going to jump ahead to the Oil Production Act topic being presented by Stefan, a very active member of our legal committee for several years. A little bit about Stefan. He's litigated in hazardous waste cleanup claims on behalf of landowners. And he has also counseled activists on land use disputes pursuant to CEQA and NEPA, and also has experience in representing shipping companies and maritime cargo litigation. He is, as I mentioned, a very active member of our committee, and he's also been an attorney on panels for legal issues with a Surfrider as well. So thank you, Stefan. I'd like to turn it over to you.
All right. Good afternoon, everyone.
Hey, good afternoon.
You heard about land drilling. You heard about fracking. You heard about local law, state law. Now you will hear about federal law. At least take you partially out of sync. So, I'm talking about the Oil Pollution Act of 1990, in short OPA. And this is what the shipping representative had to say about the law. Virtually everyone affected, except the environmentalists, think it is as the Rocky Horror Picture. Congress drafted it in an emotional bonfire ignited by the massive stroke authorities. That sums it up nicely, although from a negative point of view. So we have to ask ourselves 3 questions. What is this law that elicited this response? Why has it been enacted? And finally, is it successful in protecting the environment? There we go. So what's the OPA? It's an amendment to the Federal Clean Water Act. And what that means is there are different kinds of parties that can sue under the OPA. Individuals that have been harmed by a oil spill. The government, the federal government. Polluters that try to get other polluters in for contribution. And finally, a citizen suit is available for anyone who wants to enforce the provisions of the OPA. Strict joint and several liability is at the core of the law, which means you don't have to prove negligence, you only have to prove causation. Joint liability, you can take everyone who may be responsible for an oil spill into court and hold them liable. Several liability, if you have, say, you have polluter A, polluter B, polluter A goes bankrupt, polluter B will still be liable for 100%. It covers offshore and onshore oil spills. Subject to the OPA are vessels or facilities from which oil is discharged or which pose a substantial threat of discharge. Now there are a few exemptions. The first I will call the Navy exemption. U.S. government vessels are exempt from the OPA provisions. The second, the Trans-Alaska Pipeline is exempt from the OPA. And because there the Trans-Alaska Pipeline Act applies. Don't ask me what the provisions of that act are, but my guess is they're not as stringent as the OPA. So how did it all start? California is ground zero in terms of offshore oil exploration. In 1896, the first offshore oil drilling took place in the world, in California, at the Summerland oil field. And it looked much different than today. So what they did at those times is they built piers out into the shallow water and started drilling from the piers. Oil platforms came into existence only in the 1950s. Sometimes they would do directional drilling from the shore into the shallow water with the same effect. From the beginning, there was a tension in California between those who were in favor of further oil exploration and those who were concerned about their property values and the effects on tourism. And farmers, the oil exploratory party was prevailing for a long time. So they started building oil platforms starting in the 50s, both in the tidelands, which are state jurisdiction, 3 nautical sea miles out from the coast, as well in the federal part further off. And everything worked well until it didn't.
Yes.
And that's what happened. In January 1969, there was a massive blowout 6 miles off the coast in the Santa Barbara Channel. And what happened was the blowout preventer failed. It couldn't keep the pressure down. The oil reached the beach. Within 10 days, 80 to 100,000 barrels of oil spilled, resulting in a massive death of seabirds, thousands, and also hundreds of marine mammals. The beach cleanup took about 45 days. They fairly quickly managed to flood the well, but it didn't help because there were cracks in the ocean floor, and from there it was seeping further on for up to 1 year. It was at the time the largest oil spill offshore in the United States, and to date it is in California. But that had consequences. So what are the lessons learned there? Since 1969, we haven't had any new state offshore leases. There is a ban. The federal offshore leases had their funding cut in 1984 for a long time. It was overturned in 2008, but to date, there have been no new proposed federal offshore leases. The existing leases remain in place, though. That means to date, 24 platforms in federal waters and the 3 active platforms in state waters. Let me go back there. What also happened, of course, it's not on the slide. California Coastal Commission was started. And some key laws like the Clean Water Act, CEQA, and NEPA were greatly accelerated as a result. 20 years fast forward, and something happened that dwarfed the Santa Barbara event. On Good Friday in 1989, the oil tanker Exxon Valdez ran on a reef in the Prince William Sound in Alaska. And the resulting spill was 7 times as big as the one in Santa Barbara. The results were also massive, much more massive. Here we're talking about hundreds of thousands of dead seabirds, thousands of dead marine mammals, and what's worse, because of the frigid waters, the oil could not be broken down as quickly as it would be in warmer areas. The coast was rocky, so the oil stuck basically on the rocks. And what they did to try to get rid of the oil was they took pressure washing. And that killed basically with high pressure, they put water on the rocks, get rid of the oil, killed microbes, killed the plankton, the whole food chain collapsed. To date, the area has not recovered. There's still 260,000 gallons of oil in the soil. The litigation was massive, and it ended in front of the Supreme Court in 2008. So we're talking here about 19 years. It probably not started immediately, but the oil company was fighting the claims tooth and nails. The lessons learned: that was a single hull oil tanker, and they were not considered unsafe. The federal emergency response was completely overwhelmed. Funds were missing. And it turned out that the scope of compensatory damages was way too narrow to compensate for the economic losses that happened. Now something happened that you could not imagine today. Within 1 year, in lightning speed, Congress sprung into action. And they drafted the OPA, signed it into law, increased the liability limits for oil spills greatly, created a broader scope of damages, enhanced the federal response capability, imposed mandatory contingency planning. Now the idea was not only to create more funds for cleanups, but also to be stronger on the prevention side. And also they imposed new requirements for the vessel construction and the crews. Any claim for compensatory damages under the Oil Pollution Act has a liability cap of $75 million if it's offshore facilities. If it's onshore or ports, $350 million. The difference here is if it's offshore, you have in addition removal costs available, and they are unlimited. For vessels, it's somewhat lower. It's $1,200 per gross ton or $10 million, whatever is more. And now you can get around these caps. If the spill has been caused by willful misconduct, gross negligence, or violation of federal regulations. Civil penalties are available, and that means if the government sues, $25,000 per day of violation, or $1,000 per barrel of oil discharge, and then $25,000 of non-compliance with removal order per day. Now please keep in mind, if there is gross negligence or willful conduct involved, you can go higher with civil penalties, 4 times as high. And this will become interesting in the context of the Deepwater Horizon case, which I will later refer to. Criminal penalties are also available for failure to notify of an oil spill by a responsible party. So it's up to $250,000 a day for an individual, or up to $500,000 a day for a corporation organization. Evidence of financial responsibility has to be procured by offshore facilities or vessels and ports, and that means insurance coverage. And I think in the prior presentation by Elizabeth that came up, so if you're offshore at least for an oil platform, you need to have insurance coverage twice the amount of the normal compensatory damages. If you're talking about a vessel or a port, then it will be the maximum liability. Now the preemptive part here. We now have on various levels oil spill contingency plans, and that is mandatory. It goes down to the national level, national oil spill contingency plan, all the way down to the local level, where area plans are administered by area committees. Agencies are working together ideally in these contingency plans. Responsibility, as far as the lead agency is concerned, EPA, KCP Inland, Coast Guard for coastal waters. Also, operators have to provide what's called responsibility. And that means the owners, operators of tank vessels, non-tank vessels, could be just any vessel that's not a Navy or US government vessel, offshore facilities, and onshore facilities, to the extent that there is a reasonable expectation of discharge, have to provide a plan, draft a plan that deals with the worst case discharge scenario. And that covers oil spills as well as hazardous substances that are related to an oil spill. So what do you do if an oil spill really occurs? And now you have to go after the responsible parties, ask for money. Good luck with that. That will take a while. So what they did in the OPA was create an oil spill liability trust fund to bridge the gap until money is available from the responsible parties. It's funded with $1 billion a year. $50 million are an emergency fund for immediate cleanup. $950 million of the principal fund, that is available to claimants that are harmed by the oil spill, so that they can file a claim for the trust fund and are not forced to go to the oil company or whoever caused the spill. It's financed through a tax on the oil industry, in part at least, and more than half of the money has been transferred from other funds. 2015 was the year when the double-hull tanker has become mandatory.
Become what?
Mandatory. Took a while. Exxon Valdez had a single hull. Single hull tankers were popular because they can load more oil. But if you pierce a single hull tanker's outer plate, you have a spill immediately. Now the idea with the double hull tanker is you pierce the outer plate, you just hit the air. You have to pierce the inner plate as well to get to the oil. It's safe. It's estimated that 4/5 of the tanker accidents could have been prevented with double hull tankers. Okay. Exxon Valdez was bad. Deepwater Horizon was worse. And this was the test for the OPA. Because until then, there was no major accident where you had to see, does the law really work? Let's say it worked in part, and in part not so much. What did not work and was quickly overturned was the $1 million fund, because it was not enough money. So what the federal government did, they installed a special fund. I believe they funded with $22 billion, if I'm not quite mistaken. So the next thing that happened is along the removal costs, which were not capped, amounted to, I think it's $28 billion total, covered by BP. They had to because there was no cap. 120 lawsuits by harmed people, class actions in part, in relevant part, 80 out of 120, all consolidated in a multi-district litigation in federal court. BP attempted to settle out those claims. And they had attempted to settlement, and I believe it was in the amount of $9 billion. So they did not attempt to use the cap here, but they did something that did not fly so far. They imposed language in the settlement agreement that said they did not act with gross negligence or willful misconduct. And then they submitted it to the district judge for approval. What happened was the district judge approved only part of the settlement, and that is the settlement for medical payouts. Meaning people that had been injured and needed the money badly, they should get it. In the meantime, the federal government struck into action and sued BP, as well as the other parties, but BP was the major player. And they were going for a number of things: compensatory damages, criminal charges, and civil penalties. Their claim is still pending as to the civil part. They settled off by plea deal the criminal part. They did then something that put BP under much pressure. They moved for civil penalties, arguing that BP acted with gross negligence and or willful misconduct, which would raise the bar for civil penalties greatly. And in September 2014, when BP obviously opposed that, they said no, we cannot prove that. They said there is a subjective element, not just an objective element. There's a subjective element to gross negligence. So we have to think about it and ignore it. You have to prove that. District judge didn't follow that. In September 2014, there was a ruling by the district judge saying, 150 pages ruling, they acted with gross negligence and willful misconduct. They acted recklessly. We will say great, but what happened next? Appeal.
Comment.
They appealed it immediately.
And what's happening on the appeal?
Still pending. The ruling was in September 2014. So the appeal goes to the Fifth Circuit. It's still pending. It's anyone's guess. But this is crucial because obviously the 75 million cap is not nearly enough. The settlement is still pending. So that's not even through. The civil, if this ruling is upheld, the liability cap is gone. And also there's precedent set for future cases. Because
So why did you feel that, everybody thought that that was great, but that is the best case scenario. They could appeal, and of course we want to see it upheld. But it doesn't mean that that was a bad ruling. That was a great ruling.
no, I completely agree.
We made it
with you.
sound like, but,
It's a great ruling. The but applies to the fact that we're not really done. This was the first battle.
would you really expect Dairy Petroleum to say, okay, I did it, cap gone? Do you really expect that?
I'll tell you why they're so mad at that ruling, and they will fight it to the end. The removal costs they paid, the $28 billion, are tax income. I heard in 2010 they didn't pay any federal taxes. So, but the civil penalties are not done. Now, under normal circumstances, if there were insurance coverage in place for that accident, and then the gross negligence ruling would hurt them badly as well because the insurance was not paid. So in this case, they were self-insured. So it doesn't really apply.
However, I know where I live, Berry Petroleum sold to Lynn Energy. Are they then divesting themselves of companies, smaller parts of their company, because of the expenses on Deepwater Horizon?
Well, I don't think that would really, if that were the case, I'm not certain if that would really fly. What do you mean? That they try to avoid liability?
No.
They were just
That
raising
they
funds.
they need
Just
funds.
raising funds. They did sell several pieces of their company to raise funds to pay for these other awards.
Okay, that's a possibility. Because certainly there wasn't one that we heard bad argument so far. And if
They had to liquidate a lot of assets.
That's what I was asking.
Yeah.
And if the ruling stands, they're in trouble. I mean, they lost shareholder trust as well, so the share will go down. What is good, what I really like about the OPA, we're just 5 years into the remediation. That's fast. That's fast. Actual days took 18 years. Yes, please.
Two questions. One, what do you think about the court's finding of liability for BP as opposed to Transocean and Halliburton? And second, as an environmentalist, what lessons did you draw upon how we can use the different financial interests of multiple parties who might be responsible to try to get them to fight each other? Because I understand that was a major component
Well, to answer your first question, there has been actually part of the ruling by and I don't have it with me here, but part of the ruling of the district judge dealt with the allocation of liability between the different parties. Just grab it here
So I
because
understand that Transocean was called negligent but not grossly negligent.
yes, you're right. The district judge basically said, okay, BP was reckless. There was corporate correspondence that was discovered that indicated as much. And he said Transocean and Halliburton were only negligent. So a big difference because they're falling below the threshold. And as far as the responsibility for the spill in terms of allocation is concerned, the judge apportioned 67% of the blame for the spills to BP, 30% to Transocean, and only 3% to Halliburton. And the blow-off preventer manufacturer adopted completely.
Whoa.
So the second part with the financial interests, you know, BP certainly tried very hard to point blame to the other parties. There were a number of issues that came into play here that made them be not so proactive about that anymore. And one for sure was the temporary ban by well, still in place, I believe, by the U.S. government of granting new visas to BP in the Gulf of Mexico. So it was tremendous pressure, economic pressure, for the U.S. government on BP. But they certainly felt they had to do something. And just saying, hey, it wasn't us, it was them, just didn't win the day. They would lose money for doing so. But the lawsuit for contribution is still pending. So it's not that Transocean and Halliburton are out of the picture. They're still in the case. Does that answer your question?
I guess what I'm asking is, for us representing environmentalists and environmental interests, what lessons can we draw upon from the litigation in this case about how we can strategically nudge multiple responsible corporate parties to fight each other Because a lot of what came out in this case, as I understand it, was as a result of Transocean, Halliburton, and BP pointing fingers at each other.
What can you do? Sue them all. I would say that, sue everyone who's wrong. Because that would cause them to fight. But I'm not certain I go along with your conclusion that them fighting each other will get to a better result as a harm party. Because it protracts the litigation. It takes much longer. Yes, please. Do you have a question? Yes.
A quick one. I heard from an attorney that was involved in some way with this about a year ago that he estimated the total liability was reaching then about $90 billion. Do you have any idea of where this might wash out?
That's an interesting number because I know that BP budgeted a loss of $37 billion for the whole event. So we're going to 90. They certainly didn't think of that. Do they have it? Probably. But they didn't budget for it. Yes?
So I believe OPA has a citizen suit provision, right?
Yes, it does.
So how can we environmental activists how can we sue under OPA? Under what conditions can we bring a lawsuit?
Well, first of all, the scope of the citizen suit provision is in the Clean Water Act. But because OPA is an amendment to the Clean Water Act, it's available as well. You can sue under the citizen suit provision if you want to enforce the statute. There are several possibilities. It's your opinion, number one, that a corporation or anyone who is potentially responsible for an oil spill violates the statute, you can sue for enforcement. If you think the government does not maintain the enforcement of the statute as it should, you can do that as well. But there are certain conditions for that. So there has to be an injury in fact. So you cannot just say, well, possibly corporation over there deals with oil, possibly down the road they might violate the law. No, you need an actual injury in fact. There needs to be a causal connection between the injury and the conduct of your target, meaning either the deputy.
Does the OPA apply to deep inland ports such as Sacramento, which are several hundred miles inland from the ocean?
Absolutely. It applies, as I said, it applies offshore and onshore. It doesn't matter where it is.
All the waters of the United States even, or?
Well, yes, yes. And not just the waters
How about their oil by rail?
as well.
Yay.
As well. Yes.
So getting back to what you were just saying right now, in Montebello, we had an oil spill in 2011. And as a result of our task force efforts, it was publicized. We obtained documents about a previous spill that was in 2010, and we submitted that to the media. As a result, the district attorney turned around and sued the oil company because they failed to properly report the 2010 spill. So they were eventually pled guilty in court. They were charged with 8 misdemeanor counts. They were charged, pled guilty, and they were fined $75,000 for that. But we can establish, we have the proof in the form of reports submitted to the Governor's Office of Emergency Services of a repeat pattern of oil spills from this exact same source. So since they're showing that, that to me that seems like gross negligence on their part, that they already know that this particular oil well or some oil wells is prone to having problems that end up in the Rio Hondo River nearby. Would it be possible for us at some point to sue them, or is there a statute of limitations?
I feel that question will come with the statute of limitations. I can not tell you off the top of your head what it is. But the way you explained it to me, yes, that is a possible case, I believe, for a citizen lawsuit. Well, there is one third point before the question came in, one third requirement that you need to have. It must be likely, not just speculative, it must be likely that you will get a favorable decision. Now, the way you explained it to me, that I don't think is the major problem here. Yes, but what would be your objective? To enforce a statute against the oil company or to get the government to act?
I think at this point it'd probably be to enforce it against the oil company, because we don't trust these people now. You know, they routinely do things that, you know, we had a 10 to 20 acre fire in the oil field, and the official cause of that fire was faulty wiring on a privately owned power pole.
Possibly caused by a squirrel.
Well, it didn't say caused by a squirrel.
Squirrel.
And so we know that this company does not, has not had a very, you know, conscious effort to try to maintain their property in good working condition. And this was Plains Exploration and Production, and they were recently bought in 2013 by Freeport-McMoRan, which has an even worse environmental record. So we are very concerned that, you know, they've already demonstrated that they will get away with whatever they can get away with, and they just don't care. And, you know, they have a major housing project proposed for the middle of the oil field. And we're thinking, okay, wait a minute, you guys can't even maintain this field without people living in it. What are you going to do when the people are there?
The only concern I would have regarding the OPA here coming into play is that, in fact, you still need to, for the OPA to be applicable, you need either the spill or a substantial threat of the spill. So if you don't have that, the OPA doesn't apply. So the substantial threat threshold you still have to meet as well. But yeah, I mean, I think that's possible.
Yeah, well, like I said, there's been repeated reports submitted to the governor's office of oil making it into the storm drain and coming out the same outlet into the Rio Hondo River, which leads directly to an underground source of water recharge for the communities right next to us, where they get their groundwater resource. So this is oil that's sitting on top of the surface water. And, you know, I mean, they've had a spill a year since about 1993 or something like that.
What shall I say? It's a possibility for you. You ask me, would it make sense? Civil.
Just thinking for the future, you know,
Yeah,
just
I
in case
think
we have
the
this-
way it sounds to me, yes. I already saw a time card here, so I'll try to, 2 minutes? Okay, try to wrap it up. So, one thing I would still like to mention about the Deepwater Horizon incident was there was an effort in the U.S. Senate in 2010 to retroactively raise the 75 million cap to $10 billion. Didn't fly. There was resistance, particularly by Southern senators from both parties, saying, okay, if we do that, then only just a few oil companies can still work in this field, and we would lose jobs. Can't do it. and it never got trashed. So they had to go the route with the gross negligence for misconduct, which would be interesting to see how that plays out. So finally, so where we're in California, that doesn't really apply to us because I'm in the Gulf of Mexico. But we still have our offshore platforms that are in place. The oil reserves you see here, they may not be accurate anymore because that's the last estimate that we got from the Mineral Management Service. And basically, with fracking, there might be more than that. Federal lease is not in the planning. What happens very often off the coast is that basically the ships wash their tanks every week, a couple of times. And that you will never see in the news. Happens every week.
Oil tankers or all
All tankers, all kind of tankers, freighters, everybody. All right, I see the card end. Thank you for your attention.